Hi, good afternoon, everyone.
Afternoon, Judge.
My name is John Hurley. I'm your judge this afternoon. We're in first appearance court. Today is the day the court determines whether or not there is probable cause for your arrest. We're not here for a trial. We are not here. You can have a seat back there. We're not here to determine whether you're guilty or not guilty. The reason I tell you that is you do not need to tell us what happened. You do not need to explain yourself, defend yourself, point out any issues today about your case. It's not needed. Those things are better saved to convey to your attorney in a private meeting. Understand you have the constitutional right to remain silent. If you give up the right to remain silent, whatever you say today can and will be used against you. If you have a private attorney, when you called up, let me know who that is. We'll contact your attorney and let them know that you're in court. Now, may I see Cody Diamante?
He's not at the main jail, Your Honor, but we do have an argument.
Okay, just wait a second. Okay.
But I think it's Mickey's case, isn't it?
Your Honor.
It's Mickey's case
And
now.
I've spoken with Mr. Roque about this. I've actually spoken with the Sunrise Police Department. Count one should be burglary.
Okay, not armed.
Not armed.
Got
So
it.
he's bond eligible on that. Counts 2, 4, 5, and 6 should all be attempted burglary conveyance. And Your Honor, just to let you know, and I spoke with Monique Pilger of my office, and Mr. Roque. Judge Siegel, my understanding, he revoked his bond on his pending case, and he's going to be going into SAP.
Got it. So, what do you want to do for bond on count one?
Whatever the court's comfortable with. It's really a moot issue at this point in time. So
How about I set the bond on count one and 6 at 1,000 also?
Sounds good, Judge.
All right?
Thanks.
Just make it 6,000 total, right?
All right, thanks, Judge. Have a great day, everybody.
Got it. No problem.
Nice weekend if we don't see you tomorrow. Bye, everyone. Thanks.
Take care.
Bye-bye.
Okay. Now,
Your Honor, actually, I guess I gotta wait till I get my paperwork back on yes, yes. Can we call, I have a detective here on
hold on. We'll be right with you, all right, sir?
Christopher Clark, reset from this morning.
Okay. Now, see, Christopher Clark.
Mr. Clark is present at the main.
Mr. Clark, you have the right to remain silent. If you give up that right today, whatever you say can will be used against you. Everything is being recorded. You don't need to say anything today. If you feel like you want to tell me something, whisper it to the attorney next to you, and that attorney can tell me. Do you understand that, sir?
Yes, sir.
Okay. Mr. Clark, you're here. Count one, robbery with the firearm. 2, aggravated assault with the firearm. State, are you seeking a foreclosed bond and release conditions today?
Yes, Your Honor.
Okay. Now, before we get there, I've read the arrest affidavit here. Is there anything else you want to bring to the court's attention?
Your Honor, in addition to the affidavit, because this was obviously prepared before Mr. Clark was arrested, Detective Rivera is present in court today, Your Honor, with some additional information that's not contained in the affidavit.
Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Okay. Now, what do you want to bring out from this?
Okay.
Let me just ask you your name, sir.
I'm Detective Rich Rivera with the Fort Lauderdale Police Department.
Okay. And did you have an opportunity to investigate these allegations regarding Christopher Clark?
Yes, I did, Your Honor.
Okay, go ahead.
Okay. Detective Rivera, are you aware of any admissions that Mr. Clark has made to the Fort Lauderdale Police Department, any detectives or officers, since his arrest?
Yes,
For this offense?
last Friday, January 30th, he was taken into custody by the U.S. Marshals, at which point he was transported to the Hardy County Sheriff's Office. At that point, post Miranda, I interviewed him, and he did confess to his involvement in the robbery, Your Honor.
Involved in the robbery on December 31st, 2014 at the Westin Hotel?
That's correct.
Now, tell me about this, his confession. Was he in a interview room?
Yes, he was in an interview room with myself and Detective Jason Wood. It was being monitored and recorded, DVD
Okay.
and audio.
Did you advise him of his Miranda rights?
Yes, I did.
Miranda
And he
warnings?
acknowledged them and agreed to speak to me in regards to the robbery.
Okay, give us the sum and substance of what he told you.
He stated on that date he traveled to the Westin Hotel on Fort Lauderdale Beach Boulevard. He stated he was armed with a airsoft pistol, which he bought earlier that evening at a Walgreens or Walmart on, in West Broward near Pembroke Pines.
Okay.
He stated he paid $11 for it. He stated he walked into the Westin Hotel. He asked for change. He left because he was scared. Was nervous. He said he returned a short time later, at which time he produced that airsoft pistol and demanded the money back from the clerk. And at that point, he said he drove off and he threw the airsoft pistol into a canal.
Right. Okay, and anything else? you wanna-
No, Your Honor, that's,
Your Honor, I'd like to add, he also stated that he viewed the local media, which we did a press release on the
Right.
video. He said he knew he was wanted from that video, which is why he traveled up to Wauchula, Florida, the same night that he saw the video on the
Right.
local news.
Mr. Miller, I'll allow you a couple questions if you'd like.
Briefly, Your Honor, I
Go
appreciate
ahead.
the opportunity. Did you recover any weapon at all?
No, I did not, sir.
Did you review the video from the hotel?
Yes, I did.
And did you happen to notice on that video whether the alleged weapon? Did you see the alleged weapon on the video?
Yes, I did.
Okay. And did you happen to notice whether it fit the description of the airsoft toy?
I would object to the phrasing as a toy, Your Honor. It calls for a legal
Whether-
conclusion.
Let's say, did you,
It's consistent, Your Honor, it's consistent with what appears from a video. The camera is mounted about 15 feet away.
Right.
It's in his hand. It appears to be an actual firearm, which is in his hand.
okay,
I will say that we're still conducting initial investigation into if he did purchase something. We're pulling video from
Okay.
both those locations he stated to see if a transaction was done, but I cannot say even if we do obtain video, if that's the same weapon that was in
Wait.
his hand.
let me just ask, did you notice whether or not it had an orange tip on the end of the gun or anything like
From the
that?
video, it did not.
Okay.
It did not.
Anything else, Mr. Miller?
Nothing at this time, Your
Okay,
Honor.
go ahead, state.
And Your Honor, I would just argue that even if in fact he did buy an airsoft pistol, as the court is aware,
I don't want to beat you to the punch, but that would be his word that it would be an airsoft.
what I'm saying
Go
is
ahead.
even if it is, as the court is aware, the case law is held that for a jury can determine if a weapon is a deadly weapon based on the manner in which it is used. And I believe there's enough in the report here to indicate that it was certainly used in a manner where a reasonable person, the two witnesses in this case, could be in fear for their lives. As they stated in the affidavit, they were in fear for their safety and their life. So I believe even if it was in fact an airsoft pistol, there would be enough for legally a jury could find him guilty of robbery firearm.
But there's no evidence of it
Right.
being an airsoft.
I'm just saying, even
Go
worst
ahead,
case
Mr.
scenario.
Miller.
Well, actually, the evidence of the airsoft pistol just came in through the officer, so now we have a more reasonable doubt than we had before we walked in the door. Your Honor, I just want to call the court's attention to a couple of statistics. I went on the website for the Innocence Project, and since 1989, 325 people have been released from prison as a result of DNA testimony or DNA evidence. Of those 325 people, 30% of them had been convicted based on false confessions, and 72% of them had been convicted on false identifications. That's 98 people who made false confessions and 234 people who were identified at trial and convicted by a jury and later proved to be innocent. So I'm asking the court to consider that when considering the fact that one person in this allegation was 55% sure that this is the man who committed the crime that was alleged. One person was positive but didn't give a percentage. Okay, now we have an alleged confession. When you take all that together, Your Honor, yeah, you might have probable cause, but I don't believe you have reached proof evident presumption great. And I would ask the court, based on that, to set a reasonable bond in this case. Thank you.
Let me just ask you a question since you brought up the statistics. How many people were were exonerated who had a false confession and in the same case had a
That is-
false or an inaccurate ID?
Your Honor, I thought of that also. I'm unable to put that number together, but I can tell you because 72 plus 30 is 102, there's probably some overlap there.
Okay, so 102 people over what period of time?
No, Your Honor. 72% plus
Okay.
30% is 102%.
Right.
So there's probably some overlap. I
Okay.
cannot give Your Honor an accurate figure.
How many people were exonerated who had a positive ID, if you know, in the same case where there was a confession?
Again, Your Honor, I don't have an answer for that question. I thought about that question. I couldn't find the statistic for you.
How many people were exonerated on a confession case? False
According to
confession.
the statistic, 30%, 98 people.
98 people. And what was the pool of people who had been convicted on confessions?
I have no way of knowing that.
So it
Since
could be,
1989, Your Honor.
it could be 1 million people, right?
Your
So
Honor.
that would mean that if it were, I'm just saying 1 million people, if you had 1 million people, 98 were found false confessions.
Right, that's like 0.01%.
Right.
Is that
Okay,
right? I
just-
don't know.
we wanna
Not very
clear
good
up
at
the-
math.
Statistics. Go
There's
ahead.
also another piece of evidence. On top of one witness saying they were positive it was Mr. Clark, another witness is whether this person was 55% positive, but they still identified the same person that the other witness. There wasn't an inconsistent in identifying two different people. And then thirdly, an anonymous tipster called. And while I understand that there is case law about anonymous, it was corroborated by the two witnesses then identifying that person and then Mr. Clark giving an admission.
Okay, the court will find there's proof evident presumption great today based on a 55 or 50%. I thought it was 50, not 55.
It's 55.
But 55%, 55%
Certain.
certainty that this was the defendant who committed the crime by one
Your
witness.
method there?
The second witness, I think the bellman or the valet, was 100% sure. They have this on video from the Westin Hotel, and the defendant gave a videotaped confession to this detective that he's the one who committed the crime. And sir, I'm going to find proof evident presumption great based on the testimony today, based on the attached affidavit, and you will be held without bond on count one. Without bond, you'll be held without bond until further order of the court. Count two, that bond's $25,000, and
Just ask for no victim contact.
no contact with either victim. Go ahead, Mr.
I got this one, Your Honor.
Okay.
Your Honor, pursuant to Preston and Keel, I would ask the court to set a bond, to exercise its discretion and set a bond in this case.
Okay. The court, pursuant to Preston and the Keel case, K-E-L, out of the 4th District Court of Appeal, is of the opinion that when the state of Florida, the prosecutor, requests that bond and release conditions be foreclosed, whereupon or as a result of a finding of proof evident presumption great, this court does not have the discretion to set bond, and that the defendant's only manner of relief is to have a full-blown Arthur hearing or bond hearing before his trial judge. All right, thank you very much.
Response,
sir.
Your Honor?
Excuse me?
May I respond, Your Honor?
Sure, go ahead, sir.
Okay, so I've had an opportunity to review the Keel decision.
Yes, sir.
That's 4D14-3104. Apparently, that's the denial of a writ of habeas corpus filed by my office. And it was the court ordered that the defendant had recourse in the division to file an Arthur hearing, and they referred to two cases, Brackett v. State and Rosa v. State, both of which address the concept that a defendant has an opportunity to file for an Arthur hearing in division. My argument, Your Honor, is that the Keel case does not address this court's ability or discretion to set a bond, even in the finding of proof evident presumption great. It simply says that in this case, in the Keel case, the defendant still had further recourse before filing a writ of habeas corpus. Furthermore, I would ask the court to follow its own precedent, wherein on January 29th in the State v. Craig Koch in case 15001-254 CF10A, this court granted a bond over the state's objection in a case where proof was evident and presumption was great.
State, do you have a response?
Yes, Your Honor. My argument would be, and this is why I believe the court does not have discretion. Your Honor, there's only one type of hearing in which the court has discretion to set a bond if the state satisfies proof evident or presumption great. That is an Arthur hearing. This is not an Arthur hearing. This is a first appearance hearing. To say that the court has discretion would convert what is clearly a first appearance hearing into something that it is not. And that,
Thank you. Thank you, sir.
Your
Will be
Honor.
held without bond. Yes, sir.
May I respond?
Well,
No?
I mean, we're kind of going back and forth.
But-
I mean, we need to have some finality. I thought you had made your argument. I turned to the state, but you have a response to the state's argument now.
My only response is the court has set its own precedent by giving a bond in a first PBL over the state's objection. And I'm asking the court to follow its own precedent and to grant a bond.
Thank you, sir. Okay. Mr. Clark.
and,
Okay.
Your Honor, we're prepared to, I believe, counsel, do you want to go forward? Or
Sure.
on Ryan Yeskis, Your Honor?
Okay.
Mr. Yeskis has hired private counsel, I believe.
I
Mr. President.
Thank you. Good luck.
Okay. Mr. Yeskis, you are here. You have an attorney representing you, sir. You have the right to remain silent. You're not required or expected to make any comments today. Please do not say anything. Allow your attorney to speak on your behalf. Understand, if you give up the right to remain silent, you make any comments and any statements today regarding your arrest or what led up to you being arrested, whatever you say will be used against you. Everything's being recorded. Do you understand what I've explained, Mr. Yeskis?
Yes, sir.
Okay. Sir, how are you? Can you please introduce yourself?
Thank you, Your Honor. Ralph A. Higgins on behalf of the defendant.
Okay. How are you today, Mr. Higgins?
I'm doing great today.
Now, Mr. Higgins, your client has been charged with attempted murder, count 1, count 2, aggravated battery with a deadly weapon, domestic violence related, 3, domestic battery by strangulation, 4, aggravated assault with intent to commit a felony and domestic violence related matter, count 5, domestic battery, count 6, possession of a weapon by a convicted felon. Now, state, count 1 would be a first degree PBL, am I correct?
Yes, Your Honor.
Now, are you seeking to foreclose bond and release conditions on count 1?
Yes, Your Honor.
Okay, now, do you, state, would you like to set forth
Yes, Your Honor.
for count 1 being proof evident presumption great?
Yes, Your Honor. I would just rely upon the affidavit provided by Deputy Matthew Griffith of the Broward Sheriff's Office, relying upon Brackett v. State, where the state may rely upon a mere affidavit to satisfy proof evident presumption great at a bond hearing. Your Honor, it is clear, the deputy makes it clear that the information was obtained from the alleged victim. And I don't believe an identification is necessary based on the relationship. And Your Honor, I do believe that the elements of attempted first-degree murder are set out. Those elements being that the defendant did some act intended to cause the death of the victim that went beyond just thinking or talking about it. And I would argue that the pulling of the trigger would satisfy that act. That the second element, that the defendant acted with a premeditated design to kill, I would be relying upon the allegation that the defendant told her he was going to kill her and then discharged the firearm. And lastly, that the act would have resulted in the death of the victim, except that someone prevented the defendant from killing, or he failed to do so. And I would just argue, obviously, he failed to do so, and that the shot missed and hit the window.
Okay, Mr. Higgins, do you have a response?
Yes, Your Honor. There was no gun recovered according to this affidavit by the arresting officer.
Correct. I believe you're correct.
And there's also no indication of any damaged vehicle or any kind of a statement that he investigated a damaged vehicle with a broken window. All we have here is a statement by the alleged victim, which is a victim of domestic battery, and nothing further as far as an attempted murder. The facts as laid out here, I don't believe really establish any kind of proof that is evident presumption great that there was in fact an attempted murder.
Can I just real quick lay out the alleged facts. Dania Beach on February 3rd, 2015, 8:12 in the evening. It says that during the investigation of the case, the victim, that's Courtney Doctor, stated that about 2 o'clock in the morning, she says that she and the defendant were driving from Davie, Florida into Dania Beach. And during that, there was some type of argument. The defendant punched the victim several times in the face with a closed fist. The defendant then pointed at a handgun at her, told her that he was going to kill her. The defendant discharged the handgun while he was still pointing it at the victim. The bullet missed the victim and struck the passenger door window, shattering the glass. The defendant then struck the victim several times in her face with the handgun. The defendant also placed both of his hands around the victim's throat and neck, choking her, preventing her from breathing. The defendant walked the victim into the backyard of their home after this had allegedly occurred. When they arrived, walked her into the backyard of the residence, handed her a shovel. The defendant told the victim that she was going to dig her own grave. She was able to calm the defendant down, extricate herself from the situation. When the police or the sheriff's office got there, they said the victim's entire face was severely swollen, red, bruised. She had multiple lacerations from being punched by the defendant and struck by the handgun. The victim's eyes and lips were also severely swollen from being battered by the defendant. The victim's eyes were swollen to the point where they were almost closed. They've been dating for about 11 years. They have 3 children in common. And it says defendant was, okay, so I looked, well, we'll get into that in a minute, but now, State, I don't, go ahead, tell me, you got any response?
Your Honor, I just believe that, I believe her statement satisfies the elements. I believe it is enough for proof, evidence, presumption, grade. I would give her further credibility based on the physical, her appearance of her face. I believe physically corroborates her story, Your Honor, and that the defendant's actions. The fact that they didn't find a gun, I don't believe that, while that could add strength to the case, I don't believe, considering that this report was taken the day after, I don't think that negates.
Mr. Hagan, I'll give you one more, I'll give you the final word. Anything you want to say?
Yes, Your Honor. The abrasions to her face and the swelling to her face does lead one to believe that there was a domestic battery, but nothing beyond that.
Well, I'm going to say that I'm going to agree with the state today. The court does believe there is proof, evident, presumption, great, and the court will tell you why. These deputies arrived on the scene, and they basically say that her face is consistent with getting hit by the firearm, by the handgun. If it were just the blows to the face, that'd be one thing. But they said that the swelling to her face from being punched by the defendant and struck by the handgun. So it does seem that her injuries are consistent with this type of activity towards her. The court is going to find, based on the affidavit, there is proof, evident, presumption, great, as to count 1. And then as far as count 2 through count 6 go, the court's going to find probable cause to those counts. Now, the court notes that the defendant, yesterday, before we found out you were the attorney on the case, 2009, convicted of aggravated battery on a pregnant female. He violated his probation. He went to Florida State Prison for 40 months. 2008, convicted of battery. 2004, battery on a police officer out of Miami. 2003, contempt of court. He's failed to appear in court at least 3 separate occasions. So I'm going to just go ahead and set bonds on count 2 through 6. Do you have any comment about bonds at this time? He's going to have to eventually end up at a
Arthur hearing?
Yes. So really it's academic as to 2 through 6. But
I've advised him so, and I've also advised him to invoke his right to remain silent.
based on the level of violence and the court's concern for the safety of the alleged victim and his convictions for He's got a prior conviction, 2009, for violence against a female. He's got a prior battery on a police officer. Court's going to set his bond today at $25,000 on count 2, 3, 4, and 5, and 25,000. And I'm going to set count 6 at 25,000. Convicted felon. He was in possession of a handgun, allegedly. So I'm going to order a pretrial release with a GPS monitor. I'll waive the cost of the monitor. The court will order, sir, you're not allowed to have any contact with Ms. Doctor directly or indirectly unless your attorney does it. Other than that, no contact with her. Don't call her, don't text her, don't email her. You have to stay 500 feet from her at all times. If you do eventually get released, you're not allowed to possess guns, firearms, or ammunition, excuse me, while you're on bond. So, Mr. Higgins, I haven't seen you in a while.
Yeah, it's been fun.
But I appreciate you coming in today.
Yeah.
On short notice. And your client will be held without bond on count 1 until further order of the court. all right?
Understood, Your Honor. Thank you
Thank
very
you.
much for your time.
We'll see this doctor.
Okay, you ready to go? Okay.
Steve
Now,
said on behalf
Judge?
of everybody.
Before we begin the MO doc, can I have the floor just a moment, Your Honor?
Sure.
Yesterday, Your Honor, I made a joke at Mr. Shate's expense that upon reflection was both inappropriate and unprofessional. I do not know Mr. Shate personally or professionally. My comment was meant only as a joke and should in no way reflect upon him as an attorney. Mr. Shate, I apologize to you. Your Honor, I apologize to the court. I offer no excuse. I can only promise to work harder to maintain my level of professionally going forward.
Okay.
Thank you.
Mr. Shate's in the courtroom. Mr. Shate, you don't have to respond. You're not but I have to say something. Where's Mr. Miller?
Yes, sir. I'm
Mr.
sorry.
Miller, I have, let me just say this. I respect that you have apologized on the record. I know that I have, I've had a bad day or so in here too, along the way in 6.5 years. And I have let things exited my mouth that I regret. But in your defense, I agree. Yesterday, I'm going to agree it was inappropriate. I've said things inappropriate. But what I do appreciate you, Mr., about, even though you and I knock heads about cases and we disagree, I do think you're a stand-up person, you're a Navy man, and you've basically fallen on your sword and taken it like a man today and apologized in public, and there's a certain amount of humility there that I don't think any of us can ignore, and I do appreciate you doing the right thing, all right?
Thank you, Your Honor. I appreciate that.
Yes, sir. So, yeah, can I tell you something? Mr. Miller, can I correct you about something?
Yes.
You mentioned a case, Craig Koch, on, I don't know, somewhere in January.
Yes. January 29th, I think.
I think that the state requested I find proof evident presumption great, but
Right, and the court did not reach proof evident presumption great.
That is correct.
What I said was there was proof evident presumption great. I read the probable cause affidavit. Based on my reading of the
Oh,
case,
well,
there was proof evident presumption great. Your Honor did not find
No.
proof evident. You simply ignored it and gave him a bond.
well, I'm not sure I'd phrase it that I ignored it, but I'm just saying I thought under the totality of circumstances, I didn't think it rose to that level. If I
And I was actually, he had hired private counsel. I was all ready to make a big argument for him because I thought this was the case where you should be able to exercise discretion. But
You know what?
he
If I don't find proof evident presumption great, then I give a bond, and I have to tell you, there have been cases where I don't find proof evident presumption great, and that frankly, Mr. Linder's jumping up and down, not literally, but he's upset with me. But I'm consistent. If I find it, then I believe he's to be held no bond till there's an Arthur hearing. However, I hope you understand, and we may disagree about subjectively whether it's there or not, but I am not afraid to go against the prosecutor and say, I don't see it. We had a case the other day where we had a young black gentleman who, they said was wearing baggy pants and knocking on the window of the car. I said I thought there were a lot of young men in that neighborhood who fit that description. I didn't find proof evident presumption great. So I hope you realize that, I'm not rubber stamping anything. I call them the way I see them, and sometimes it goes their way, sometimes it doesn't go their way. But
Your Honor, what I hope at someday, what I want to have happen is for the court to just go ahead, find proof evident presumption great, grant the bond, and allow the state to appeal, because we're not ever going to win this appeal. And until the 4th DCA rules on this issue, it's always going to be an argument. And quite frankly, I'm tired of making it. I'm tired of hearing it.
Got it.
All right,
Sir. Okay, got it. So, you know what? I'm going to take about a 2-minute break. I'll be right back. Okay. Now see James Patrick followed by David Filoso, followed by William Davis. Okay, we have Mr. I always mispronounce your name, sir.
Okay, Andrew Laney, City of
Laney,
Hollywood,
all right.
standing in for Fort Lauderdale, Your Honor, here with Stephen Shade.
Got it. Okay, Mr. Shade, how you doing?
Good, Judge.
Hey, Mr. James Patrick. Sir, you have 2 municipal ordinances, sir. Trespassing,
Yes, sir.
disorderly conduct. Disturbing the publics, they said. Intoxicated. Told by the officer to leave the property. Defendant dropped the F-bomb. I'm not going anywhere. That's me. He didn't say F-bomb. I did. While pointing his finger, yelling at the police. They said he was intoxicated when this was going on. And the subject yelling, cursing, gathering at the location. He wouldn't leave the area, drunk and cursing everyone. And so this happened around 5 o'clock yesterday. Okay, so do you have any comment about Mr. Pat? Do you still live on 3rd Avenue, Wilton Manor, sir?
Yes, sir.
How long have you lived there?
Probably about, 8 years total. I lived in an apartment in the front. Now I live in the rear apartment.
Okay, all right.
I'm on Social Security disability, and
I
every
understand.
once in a while I have a drink. And,
Well, you
That's-
probably want to knock out that once in a while. It seems like you maybe
yeah, I know.
you probably can't handle it right now. You know, you don't
Yeah.
cut back.
Right.
When you have an alcohol problem, you don't cut back. You go cold turkey. You know.
Yeah, I
Okay,
know.
so what do you want to do?
Your Honor, Andrew Laney, I have no comment, Your Honor, withhold time served per count would be fine for
I agree. You want to work it out right now, sir? Plead no contest. Case is over with. That's the end of it. You're done.
Yes, Your
I
Honor.
understand we're not going to have a trial. We're not going to point it. Well, let me ask you, do you need an attorney to help you make this decision today? You want to sit down?
No, I don't.
Okay.
No, I don't.
All right, sir. You live in Wilton Manors. Is there a closer Publix to you over there?
Yes, there is.
Okay. So don't go back to the one at the Coral Ridge Mall, all right?
Yeah, okay.
All right. How do you
You're
plead,
right.
sir?
No contest.
You can go to Winn-Dixie too, sir. I'm not going to keep you away from it. All right.
Okay.
Sir. I'm going to withhold adjudication. Good luck. Thanks.
Hey, thanks.
Patrick, what happened?
Without adjudication.
Yeah, you have
Clerk.
Okay.
He didn't say a fine.
Hold on one moment, sir. Hi, we have the family here for Christopher Clark. Am I correct?
Thanks a lot.
Okay. We took care of that case about 15 minutes ago. The attorney was here, Mr. Hagens.
No, that was on the Yeskis case, the public defender's representative.
Oh, okay. Remind.
Yeskis, that was the domestic violence attempted murder that Mr. Higgins was on. Christopher Clark's the robbery firearm of the...
From the Weston?
Yes.
Got it. Okay. We handle. Let me ask you, how do you know Mr. Clark? Okay. Let me do this. Let me. Could I have those 2 young men just step out the door real quick? How old are you, the bigger boy? How old are you? Okay, keep an eye on the younger one out there. Just go right out the door real quick.
Money in the bank.
Here you go. Can you all step right up here where Mr. Shade is? I didn't want to discuss this type of thing in front of the kids.
You've been arrested.
Stand by, Mr. Filoso. We'll be right with you. Okay.
Okay.
Let me ask each one of your names, man. What's your name?
I'm Arlethea Clark.
Thank you.
Leonard Clark.
Okay. We had your son in here a few moments ago before you got here. And what I did was I ordered that he be held without bond. He's going to have to go to his judge, his division judge, trial judge, and have a hearing there to determine whether or not he can have a bond. I decided not to give him one today, and I'll tell you why. He allegedly robbed the Weston Hotel down on the beach in Fort Lauderdale. The woman behind the desk had a gun pulled on her, and got robbed for, I think, a couple $100 in money or something in a bag around 5 o'clock-ish in the morning. Now, it was captured on videotape. They have videotape, security there. So that they see it all go on. They see the person who did it. I don't know if you could tell from the tape exactly the facial features, but on the way out, the person who robbed the woman behind the counter still had the gun, and the porter or the person, the valet, allegedly, he gets the gun aimed at him, and the person says, "Get out of the way." Well, the person behind the desk said they were only 55% sure it was your son who committed it. But the valet, he said he's 100% sure that your son's the one who committed it. The last part of it is the police got your son in a room, interviewed him after they read him his rights, and he allegedly confessed to being the man who robbed the Westin Hotel that evening. So, based on all those factors and the serious nature of the allegation and the crime, I ordered that he be held, and he'll have to have what's called an Arthur hearing before his trial judge. And at that time, his trial judge can weigh all the evidence and the issues and decide whether or not to give him a bond or release him from custody. Now, let me just say one thing, that I enjoy my job, and I'm very fortunate to be your judge here in Broward County. However, there's one part of my job I don't enjoy, and that is to tell people that good people like you bad news. I don't like doing it. It doesn't make me feel good. I don't take any pleasure in doing it, because I can tell by looking at you, you seem like good people to me. And I know that this is a very difficult moment for both of you, and it breaks my heart to have to tell you this kind of news, that I'm going to hold him in jail and your son's been allegedly involved in this type of activity. But that being said, right now the public defender is representing him, and they have very fine attorneys in that office. And I mean, for your son's sake, if he's not the person that did it, and it comes out later on, I hope that you get that kind of news. But today I felt that I had to follow the law and the facts and just hold him without bond. All right?
Well, Your Honor, I really and sincerely appreciated that. I just recently retired, and
What type of work were you doing?
I worked for the State Department of Corrections, Internal Affairs, for 23 years.
Wow.
Out of the 30 that I was employed by them.
That's good.
My son, if he actually did this, there was absolutely no reason for it. He had everything. He lived with us. He don't want for nothing. He don't need anything. I'm baffled. I have no understanding of why
Well,
this happened.
okay, the downside is you're here in front of me today, and we're trying to figure out what goes on. However, the upside is there's going to be a period of time where the prosecutor has to produce the video, they have to produce the sworn statements, they have to produce witness statements, witness reports, and you know what? A good attorney, whether it's the public defender, you go out and hire a private attorney, they're going to be able to peel through this and look through and see if it all adds up. So don't think this right now is a slam dunk. There's going to be time for an attorney to look into this and figure out. Before I became a judge, I used to do this type of legal practice, and many times they'd say, "Oh, your client is, we've got a 100% case on him," and then after I looked into it, you figure out that it doesn't really all add up. So I don't know if that is going to happen in this case, but just don't lose the faith, don't lose hope, all right?
Thank you very much. Do you have his public defender's name and the judge?
I don't know if we know who that is yet.
No, and I don't mean to speak for you. He wouldn't have been assigned a public defender yet, and because it's an arrest warrant, the case will have to go to the clerk's office, and then they'll randomly assign a case number and judge.
It's so new that they don't even have a public defender assigned, and they don't have a judge or a case number assigned. That'll probably happen in the next couple of days. They'll get the assignment for everything. Case number, public defender, judge will follow. All right?
All right, thank you.
Okay.
All right, have
You know, like I say, I'm sorry we had to meet under these circumstances. I wish you both the best. All right?
Thank you.
Thank you very
Yes,
much.
thank you.
It's a long
So,
story, George.
Messi David Filoso.
Yes, sir.
Sir, you're here on a count one is a warrant, and that is for a theft. Count two is an open container of alcohol. I don't know what the theft is about.
I can find that out.
I know state on count one, municipal on count two. Municipal comes from 2011. It's from the city of Hollywood. It's for open container of alcohol.
Okay, on the state.
Are you working at this time, Mr. Filoso?
No, sir, I'm on disability.
Okay. Do you have any money in the bank?
A little bit.
Okay. Who's going to bog you out today if you...
My mom is.
Okay, go ahead, state.
One moment, Jacob. Okay. He allegedly went to Publix, stole a little under $50 worth of items, food items.
Failure to redeliver a higher vehicle, that's also 2005.
I mean, I guess they recovered it as well, as good as they could.
Really?
Well, I mean, it's like, frankly, I mean, there was sushi, there was steak. I don't know what they do with it. I mean, I don't know if they can necessarily put it back on the shelf.
No, they can't. Well,
I mean,
they're
they
not
could,
supposed
but...
to. Let's put it that way. You know? I mean, we trust in our local grocers that if somebody carries something out of the store, they're not going to walk back in and throw it back on the shelf. But I guess it all depends on
comes to stolen items.
the honesty of the employees there.
As far as priors, as far as Broward goes, 2003, resisting without violence, disorderly conduct, reckless driving. Resisting without violence, reckless driving 03, 91 resisting without violence, criminal
So
mischief.
would you like to resolve both these counts today?
Yes, sir.
How do you plead to count one theft, count two municipal ordinance? Well, let me
No
stop you there.
contest.
Do you need
All
to
right.
sit down and talk to an attorney about resolving these cases, or can you go without an attorney?
I think I can go without an attorney.
All right, how do you plead to both these counts, sir?
No contest.
You understand we're not going to have a trial, we're not going to appoint an attorney, it's over with right now?
Yes.
Okay, I'll withhold adjudication, don't go back to that Publix.
How do you want it resolved?
Thank you.
Thank you.
Where you going?
Okay, William Davis. Mr. Davis? Sir,
Yes, sir.
you have municipal ordinance, sir, for battery, and Kaiser University, they asked you to leave. You allegedly went up and took a punch at the security guard there. Do we have any priors on this gentleman?
One moment, Your Honor.
And his name is William Davis. Davis, do you still live on 49th Street in Fort Lauderdale?
No, sir. No, sir.
Where are you
I don't
living
stay there.
now?
I'm homeless.
You're homeless now?
Sir. Yes,
How
sir.
long ago did you live at that address on 49th?
49th Street. I don't even know where 49th Street is actually at, but I'm not from Fort Lauderdale. That's why.
Well, how long have you been down here in South Florida?
My whole life actually, but I'm not familiar with Fort Lauderdale. I don't know where that address is.
Okay. Are you currently employed?
No, sir.
Do you have money in the bank?
No, sir, none.
Do you have any income?
Look over there.
No.
Do you get any checks or anything?
No, sir.
Okay, go ahead, Steve.
Check. Okay.
Is this? Excuse me. I was wondering. Is this why it's on?
Okay.
All questions.
He was arrested January 22nd in Boynton Beach for
That's my
resisting
public
without
defender.
violence. He pled that out. Your Honor, it looks like he was Baker acted last year in Palm Beach. Marchman acted in 2011 in Palm Beach. Again in 2011 in Palm Beach. Wait a second. That's all I have.
Okay. So I'm going to go ahead and I'm going to, wait, hold on.
Excuse me, Your Honor.
Yes, sir.
I wouldn't say anything about
Never
the
mind,
case,
never
sir.
mind, never
Don't
mind.
say anything, sir.
Okay, so I'm going to set your bond at $1,000 based on your lack of ties to the community, your recent criminal record, and I'm going to order this go to Judge Lerner Wren.
Thank you.
Thank you. Oh, wait, hold on.
Sir,
Sir, you don't have any
Your
money
Honor.
in the bank, right?
you're right.
I'm going to, I suggest I appoint an attorney for you. I think you're going to need an attorney, all right? I'll appoint a special public defender for you, all right?
All right, thank you.
I'm going to appoint Steve Shade to represent you.
Kilo deals.
You got? All right, what about John Dawson?
What's your name, John?
John Dawson.
Thank you.
Mr. Dawson, hey, sir, you're here for sleeping on public property or lodging on public property. State, do you have any priors on Mr. Dawson?
One moment, Your Honor.
Mr. Dawson? No. Mr. Dawson, do you have a place to live now?
Yes,
Where do you live now?
yeah. I live in Boynton Beach,
Okay.
9843 Pavarotti Terrace.
In Broward? Or was it traffic?
Okay.
That was last year.
I just soon resolve this. You want to?
I have no argument on it.
You want to?
But open container.
You want to plead no contest to lodging on
Yes.
city property, and I'll withhold adjudication. You're out of jail today. You want to do that?
Yes,
Let me ask you, sir. Do you need me to give you an attorney, appoint an attorney if you can't afford one to help you make this decision, or can you go without an attorney?
no, I'm fine without an attorney.
Okay. How do you plead, sir?
No contest.
Okay, I'm going to withhold adjudication. Good luck. All right.
All right, thank you.
Yeah. How about Kevin Gabriel?
Hold on a minute, step outside first.
Step outside.
Right there.
All right, here.
Go down, outside, yeah.
Sir, urinating in public. Court finds probable cause. Self-surrendered. Okay. Do we have any priors on Mr. Gabriel?
Yes, Judge.
Gabriel, are you on the street? Are you homeless at this time?
No, I'm not.
Where do you live now?
I'm staying with a friend off 17th Street.
Okay. And are you currently employed?
No, I'm not.
Okay.
That's a defense, and the defense.
Any priors on it?
Yes. His last arrest was October 15th of last year. That was for
You want them? All right.
trespass on a municipal ordinance. Before that was April 24th of 2013.
Okay, you want to plead no contest to this today, sir? The case is over with. You're out today.
Yes,
Is that
sir.
what you want to do?
Yes, sir.
Do you need me to give you an attorney, appoint an attorney if you can't afford one?
Yes, sir.
Okay. So how do you plead, sir?
No contest.
Okay, I'm going to withhold adjudication, all right?
All right.
Good luck,
Okay.
sir. Thank you.
Thank you.
How about Brian Robbins? Mr. Robbins, you're here for municipal ordinance, street solicitation, panhandling on Atlantic Boulevard in Pompano around 10:30 in the morning, holding a cardboard
Yes, sir.
sign, walking from car to car. State, do you have any prayers on Mr. Robbins? Mr. Robbins, do you still live on 23rd Avenue in Pompano?
Yes, I do.
How long have you lived at that address?
A few years.
Is that a house or is that a apartment?
It's an apartment.
Okay.
Okay, his last arrest in Broward was in 2011.
Okay, I just assume resolving today.
I would say.
Look, I'll resolve it today. Let me just remind you, Mr. Robbins, you haven't been arrested in a couple of years. It doesn't appear you're homeless. Not that being homeless is an excuse, but you got a place to live. Standing on the side of the road at 10 o'clock in the
I had to
morning.
come up with rent that one day.
Well, you could probably do something else, wash your car, cut somebody's lawn, but standing walking through traffic you're not supposed to do that, all right?
Yes, sir, Your Honor.
All right. How do you want to work it out today? You want to plead no contest?
Yeah, most definitely, yes, no contest, Your Honor.
Okay, do you understand? Well, let me ask you, do you need me to appoint an attorney to represent?
No, I don't.
Okay, do you understand the case will be over with today? We're not going to have a trial, we're not going to appoint an okay.
Yes, sir, I do.
I'll accept your plea, I'll withhold adjudication. Good luck, sir, thank you.
Thank you.
Okay, how about Robert Titus? Titus.
That's North Broward, Your Honor.
Mr. Titus, you're charged with 2 municipal ordinance violations. Those are from last year. One is alcohol beverage violation. The other is sleeping or lodging on city property. So it says here, observed defendant sitting on a bus bench next to the Publix with an open can of beer at around 9 o'clock in the morning. Contact was made to the defendant. Got it.
I think you should make it.
Yep.
A couple?
All right. Do you have any?
He was arrested in November of last year on a capias for littering municipal ordinance, and then August of last year for a capias on count 1.
Okay. Mr. Titus, how long have you lived down here in South Florida?
I forget, actually, like 2 years.
Okay. Are you employed, sir?
No, I get Social Security.
Okay. And do you have any money in the bank?
Yeah, I do, as a matter of fact, yes.
How much do you think you have?
County Main I forget, but I don't know. I'll just throw this out. 8 or 7 something.
I forget.
Hey, do you know where you are right now, sir? Which building are you in?
Pompano jail.
Okay. And let me ask you,
Transferred
what?
out to.
Yeah, who's the president of the United States right now? Do you know?
Sure.
Who are you looking at now?
Yeah, Obama.
How many states are in the United States?
So, where are you looking at
53 now, isn't there?
That's what the girl said yesterday.
No, she said 53.
She did. She said 53. There should be 53. There's only 17.
I can't. All right, I'm sorry.
Can I tell you? You know what, Mr. Shea, I think this is marginal whether I want to resolve this. I think it's better I send this to Lerner Wren.
Is it a time served, Judge?
Yeah, but I'm just going to send it to Lerner Wren. I'm going to appoint you to represent Mr. Shea. I'm going to appoint an attorney to represent you, right, sir?
Okay.
Thank you. Well, let's look. Mr. Shea.
Tuesday. Monday.
Okay.
When's my next court date?
Probably Monday. All right?
Okay.
Good luck. Thanks.
Can you put your leg down, please? Thanks.
Okay. How about Alexandra Negron?
Ryan Facility, Your
Hello,
Honor.
ma'am. You are here for possession of paraphernalia. That's a warrant. I believe it's not showing up in court. And
there.
Yeah, it's also, ma'am, alleging you're involving in you're getting yourself involved in prostitution also.
I'm not, Your Honor.
Well, that's just what the police said.
I'm looking for work.
Yeah, well, that's part of the problem. State.
Last arrest in Broward was in Last arrest in Broward was 2010.
All right, ma'am, what do you do for work? What do you do? Turn on your mic. I can't hear you.
Waitressing. I clean houses. I've worked in animal hospitals. I've done a few different jobs.
Got it. Would you like to resolve your case today and plead?
Yes.
You probably have 2 children. Am I correct?
3.
3.
Yes.
John, Paul, and Nico.
John. Yes, and Angelina.
Angelina.
Yes.
That's 4, isn't it?
She's my 9-year-old. Huh?
That's 4 children.
No, John Paul is 1.
Oh.
Nico is 2. Angelina is 3.
Oh, okay. Well, you don't have the Angelina tattoo yet.
No, not yet.
But you do have the John Paul and the Nico. All right.
Yes.
So, ma'am, would you like to plead no contest and resolve your case today?
Yes.
Do you need me to appoint an attorney if you can't afford one to help you make the decision? Can you go without an attorney?
No, sir.
All right,
No,
ma'am.
sir.
How do you plead to this charge?
No contest.
I'll withhold adjudication, ma'am. Good luck. Thank you.
Thank you.
How about Dina Myers?
Can I go back?
Your Honor, it's come to my attention for Ms. Myers that she does have a pending second and third degree felonies as well.
Interesting.
As the municipal ordinance violation.
Where is Miss Myers?
Patrice, you took care of that this morning,
Miss
right?
Dina Myers.
What's Broward, Your Honor? Come on, Myers.
Ma'am, do you have any money in the bank?
No, $500.
Are you employed?
Going to school,
Going to
and I do
school?
hair on the side. Yes,
Okay.
sir.
And, all right, ma'am, I'm going to set your bond today at $100. And I'm going to appoint an attorney to represent you, Steve Shate. All right, ma'am?
Okay, thank you.
Okay, thank you, ma'am. Mr. Shate, you're on this, all right? There you go. Thank you. I think that is it.
Samantha Connolly is also on my list, Your Honor.
Oh, just okay.
Her name is Connolly?
Connolly.
Can we just melt it on the stove top?
I don't see it. Ms. Connolly.
Got it, okay.
Hold on, let me look.
I don't know.
Who's George?
Do we have Miss Connolly over there?
He was what?
I don't have it. I may have taken
George
care of it.
Nooner?
Okay, well, Your Honor, thank you very much.
Thank you. Good
You have a
luck.
wonderful afternoon.
You too. Thank you. Okay, now, may I see Shanti Baez?
See on the dock.
Just give me a moment real quick.
Yeah, I can't do anything on you either.
Okay, hang
Let me ask you.
Good job. And I think thanks to it might, well, Canadian or U.S. Thanksgiving. Can you get Christina something? Yeah, just give me your. Just give me your 7911.
You want to call me?
If you want, you have to do it though. I can't.
What do you need? Okay, yeah, give me a moment.
Well, you don't have to, I mean, you can if you want, but, okay.
So, would it be a medical reset? Hey, be around. All right. Thank you.
Is the whole clove? Is canola oil okay? Hey, didn't know if you. Okay, next. What are you trying to have your own cooking show?
I like to do 4:15, maybe 12 minutes.
It depends. It depends how you. It
I
depends
think
what
it comes
you
out of the
like.
panties, you know.
And that's it. In the shell, obviously.
Yes, so what?
What?
You didn't hear him say that. You don't want to know.
Okay, now Shanti, let me just do Shanti Baez. Ma'am, you're charged with domestic violence, court finds probable cause. Do we have any priors on Ms. Baez?
No priors, Your Honor.
One moment, Judge.
Do you have anything you want to add, Mr. Miller?
Yes, Your Honor. Ms. Baez is a 23-year resident of South Florida. She's been at her current address for 2 months. She is a realtor licensed by the state of Florida. She has one child, strong family ties, is less than $1,000 in the bank, no real estate. She will have a place to stay. separate and apart from the alleged victim in the case, and she's hoping that her family will bond her out. We're seeking pretrial release.
Okay, let me just say, ma'am, how old is your child?
She's 17.
Does this, does she have any prior state?
No, Judge.
No? Okay, ma'am, you're the live-in girlfriend, allegedly became enraged, approached Mr. Corneo and squeezed his, let's just say, body part, plural, and it says it caused him,
You don't boil the person.
allegedly struck him 4 to 5 times on his face.
You don't even eat a crack or anything. You just break them.
Allegedly chased him and continued to attack him. He had scratches and red marks throughout his body. Okay, so, all right, ma'am, just based on the, let me ask, Miss Ashley, was there contact on that?
No, Your Honor.
Okay. Okay, ma'am, just based on the level of violence, I'm gonna set your bond today at $3,500, and I'm gonna order that you are not allowed to have any contact with Ricardo Cornejo. Do not have any contact with him. Stay 500 feet from him at all times. That's where he lives, works, goes to school, anywhere in between. You're not allowed to possess guns, firearms, or ammunition while you're on release. Thank you, ma'am. Thank you. George Nooner. Do you have George Nooner over there?
Standing next to me, Your Honor.
Hi, Mr. Nooner. Trespassing.
Hi, sir.
And criminal mischief. We have Mr. Shea.
Trespassing crowd, right?
How you been?
Okay. Okay. State. You gonna represent him? Okay. Go ahead.
Frankly, I believe this is going to be an executive assignment. I can't really do anything on it. I don't know if pre-trial might have any notes.
Hold on one second.
Okay, gotcha. Yeah, no problem. Also, if you want to look in, I told the truth, but you want to look into it.
Okay.
For whatever reason.
Judge, is Mr. Shade going to be representing Mr. Nooner?
For today, yes. Probably in the future. Mr. Nooner,
I'll step aside.
I'm gonna set your bond today on count 1 at $150. Count 2 will be 100.
Wait.
I'm gonna set this bond. I'm gonna set this over to Judge Lerner Wren. Total bond's
Sir?
$250. Yes, sir. What can I do for you?
I'm sorry to interrupt. Sir, what I was hoping for was an ROR today. All my stuff was in that storage unit. Can you hear me, sir?
Yes, sir.
Okay. Sir, I've been in the South Florida community for 42 years. I'm a physician. I'm trying to get back to my job, my kids, my wife. But all my assets right now were in a storage unit that I had. It was under my father's name, but it's my unit. It's all my things. And my father decided to change a code or change a lock. I don't know. But I spoke to the owner. He said, you have until today, till 3, to get whatever you need out. I said, that's fine. And that's when all this happened. Now, I don't have any cash directly on me. I'm kind of estranged from a lot of my friends. But Your Honor, if you could please find it in your heart to just ROR me today. I'm not a flight risk. I'm going to come back and resolve this. I believe I know Mr. Shea and his brother. I think I played soccer with his brother.
Right.
But if you could really help me out today, that would be exceedingly helpful. I love South Florida. I love Fort Lauderdale. This is my home. I'm not going anywhere, and this is just a big mistake, sir.
Yes, sir. Let me ask you. I'm going to go sidebar. Sure, I'm going to leave your bond at 150 on count 1, 100 on count 2. I'm going to go ahead and reset this case for Judge Lerner Wren. Thank you, sir.
You might probably right.
How about,
Sorry, Mr. Noonan.
no problem. And Paul Woodward, Shaquan Roberson,
Here, I'll tell you.
Cabricia Mansfield. Paul Woodward, assert domestic violence battery. The court finds probable cause.
Who's this, Woodward?
Allegedly backhanded your 14-year-old brother, gave him a swollen bruise under his eye. Says you're 21 years old. I need a
And he's present at the main, Your Honor.
I need to appoint a guardian for the child.
Your Honor, he had a possession of a self-propelled knife in 2011. Misdemeanor.
All right.
Okay. Here's how it works.
Sir, are you currently employed, Mr. Woodward?
Not to the best of my knowledge.
To the best of your knowledge, you're not employed? Okay. And have you been employed recently, sir?
I received a tax return, but my mother took it, and I don't know how much I got.
Okay, well, aside from your tax return, have you been employed recently? Have you been employed in the last year?
Apparently, yes, I received a tax return.
Apparently, you've been employed. Well, do you have any idea whether you've been employed? I mean, can you say with any certainty whether you've been employed in the last year?
The last place I applied at, a homosexual man yelled curse words at me and told me that I would never work there. And the place before that, I was riding about 12 miles every day, and the security at the facility cut my lock. So I stopped returning to that facility.
I would say. Okay. On that note, do you have any money in the bank? I'm on board on this from Mr. Miller. Do you have any money in the bank,
I have
sir?
not had an opportunity to talk to him.
Sir, do you have any money in the bank?
Which is after this.
Money in the bank.
Negative 34.
That's no, Your Honor.
Negative $34?
Yes.
Okay. All right. State, that's all he has. Okay. I'm going to appoint guardian ad litem for the child.
Judge?
Yes, sir.
Mr. Woodward did not fill out any application for my office's services. I would ask the court at this time to go ahead and appoint my office to represent him.
Okay.
I'm good.
Let me talk to Mr. Woodward. Mr. Woodward, do you have any money available to hire an attorney on your own?
I don't think it's necessary.
You don't think what's necessary?
An attorney.
Okay. Why do you think it's not necessary? Let me ask you, have you ever
Deus ex machina.
Have you ever received
That means by the machine of God.
Have you ever received any legal training? Have you ever gone to paralegal school or law school or read any legal books?
I've read your name before somewhere, but I can't recall where.
All right. Mr. Miller, I'm going to appoint...
Yes, Judge.
I'm going to appoint the Public Defender's Office. I think it's appropriate in this
Thank you,
case
Judge.
to be...
Can I outrightly deny that?
Excuse me?
Can I outrightly deny that offer, request?
I'm
Whatever
gonna
this is.
I'm going to appoint the public defender today, and you can bring this up with your next judge. And if you don't want an attorney in the future, your next judge can rule on that. All right. But for today, I think it's in your best interest to have the public defender's office kind of keeping track of your case and making sure you're getting to court. They'll make sure you get to court in a timely fashion. So actually, it's going to help you. So you don't just languish over there, all right?
No, thank you.
Yes, sir.
And do I have the option to deny that? I've asked before. You didn't really exactly answer me.
You do have the option, but I'm not going to let you exercise the option today. I'm going to go ahead and I'm going to have the public defender's office assigned to the case, and I'll let your next judge...
I've been exercising all day, whoever laughed.
Okay. All right.
Judge? At this time, based on the facts of the case, this is a fight between brothers. It was an open-handed slap. I don't know.
I think he got the black eye. Ramming me. He tackled me and hit a wall.
I would ask the court, and it's going to be the family, obviously, who posted this bond. I would ask the court to set a minimal bond in the case under the circumstances, and we'll follow through with all necessary appointments and evaluations.
I'm going to set your bond at $1,500 based on the level of violence the court's concerned for the safety of the alleged victim. And I'm going to order, sir, you have no contact directly or indirectly with your 14-year-old brother, whose initials are PW. Well, it looks like they're about the same as yours, PW. No contact with him directly or indirectly. Thank you, sir.
Can't hurt.
He looks all right. How about Shaquan Roberson? I think it's great, maybe.
Mr. Robinson is present at the main, Your Honor. He has declined the services of the public defender.
Okay, sir, domestic battery by strangulation and domestic battery. The court finds probable cause, Mr. Robertson. State, I'm going to find probable cause based on Judge Ross's
Yes,
warrant.
Judge. 2010, resisting with violence, resisting without violence, 2-year state prison. 07, grand theft auto with VOP, 2-year state prison. 07, robbery with a firearm or deadly weapon with a VOP, 2-year state prison.
Is that interesting?
Yes.
Great. Oh, you are staying?
Yes.
You were just a little bit too far away, though.
Now, sir, are you currently employed?
Yes, I am. I'm supposed to be at work right now.
Okay, what type of work is that?
I move furniture locally for Nationwide Moving and Storage.
Do you have any money in the bank?
I do not have a bank account. I just recently got denied for a bank, but I do have money saved.
How long have you lived down here in South Florida?
All my life, sir.
Ma'am, was there any contact with the alleged victim? Okay. Applied pressure. Throat of Emily Montino, blocking her nose and mouth. And actually, sir, you have been convicted of violent crime in the past too. Resisting arrest with violence and robbery with a firearm or deadly weapon. Go ahead.
I was a juvenile at the moment, sir. I'm a full adult. I done changed. I'm working man. I take care of my kids. I have 3 of them, 6-year-old, 15-month-old boy, and a 3-month-old daughter.
So your bond on count one's going to be $5,000, two $1,000. Your total bond today is $6,000, and that's based off Judge Stacey Ross's warrant. Based on your criminal record, I'm going to order you have no contact, directly or indirectly, with Emily Montino. Do not call her.
Yes,
text. Go ahead. What?
Yeah, I'm sorry to cut you off. Go ahead, finish.
Is she the mother of your children?
Yes, she is. I was going to tell you that I did find another place for the meantime because I do not want to be at the house with her. So
How many children do you have with her?
I have 2 children with her.
And how old are
and
those
I have
kids?
A 15-month-old boy and a 3-month-old daughter.
Do you visit your children? Do you see your children?
Yes, they stayed with me, but I chose to leave the house because of this case right now.
Right. Okay. So the kids are living with you, not with her.
we all stay together, sir. I'm sorry if I'm getting you confused. I'm
No,
sorry, but
no.
I moved. I took the opportunity to leave the house and leave her at the house with the kids.
Okay.
Sir, I work every day. I'm supposed to be at work right now. I got my boss on standby waiting for me, and I'm just trying to get back on the path.
I'm going to set your bond. I'm going to reduce your bond on count 1 to 4,000. Count 2, 1,000. Your total bond's 5,000 today. Then what I'm going to do, sir, is I'm going to order you. I'm going to order you have no direct or indirect contact with. I'll allow indirect contact with Miss Montino. Go through a family member or friend. You can see your children. Just stay 500 feet from her at all times. All right?
Yes, sir. I understand.
Weapons while you're out. Thank you.
Can we call 30-day?
All right. Thank you.
Yeah. Let me just take care of it. Kerbesia Mansfield.
Judge, she's present at the main, Your Honor. I understand that this is a rather new case. I just asked the court to take into consideration the fact that she turned herself in on the warrant. I was wondering if the court can resolve this today. She's ready to admit.
Hold on one moment. Is this a VOP?
It's a VOP.
It is.
DWS allegedly committed another DWS.
Ma'am, do you want to admit you violated probation?
Yeah.
Yes.
Well, if you admit today, the case is over with today. You're not going to have a final hearing. You're not going to have your day in court. You're not going to have a trial. You're not going to have an opportunity to have an attorney represent you on this violation of probation. You're not going to be able to tell the judge your side of the story. You're not going to see the evidence or talk to the witnesses against you. That's because it's over with today. There'll be no action taken after this hearing. The case will be closed, and this will be behind you. Is that what you want to do?
Yes.
Do you admit you violated probation today, ma'am?
Yes.
Okay, ma'am, I'm going to revoke probation. I'm going to give you time served. Thank you, ma'am. Okay.
Thank you. Good luck. You're done.
Missy Kayla Sullivan on page 3 of the afternoon docket.
I believe she's at Paul Ryan, Your Honor.
You don't have to go into your
Ryan
computer,
facility, Your Honor.
Judge. Your Honor, we have not yet filed an information. She's entitled to release. I would just ask if the court would instruct her that there's still no contact order in place.
Ms. Sullivan on 15-119 CF10, the court will order you be released on your own recognizance today and remind you you're not allowed to have any contact with the alleged victim, all right?
Yes, Your Honor.
Your Honor, one additional thing on that case, I did file a motion to withdraw, Your Honor. We represent Jeffrey Dowdy, who's a co-defendant. We've represented him on prior occasions. Based on that conflict, Your Honor, we'd be moving to withdraw off of Ms. Sullivan's case.
Okay, that'll be ordered. Ms. Sullivan, you're going to be released on your own recognizance. How is she going to find out about her new attorney? It goes to...
They're going to have to file, I guess you could order to have a...
Regional counsel.
Well, no. I mean, no, what'll happen is if the information does get filed, they'll send a notice for arraignment to her address. And then they'll also schedule a hearing to have counsel appointed.
Well, at this time, Your Honor, also, when I filed the motion through Odyssey, Your Honor, I did notice regional counsel.
Okay.
So they were aware, their office.
Okay, ma'am, you're not going to have the public defender's office. You're probably going to end up with the regional counsel's office, which is kind of like the public defender in another office. So when you go to court, make sure that before you leave there, you straighten it out with the judge that you need an attorney and the public defender's office can't be on your case.
Well, and more importantly, she needs to keep checking to make sure to see if she has a court date if the charges are filed.
Go onto the computer, the clerk's computer in Broward County, and keep checking your name to make sure you know when your court date is, all right?
Yes, Your Honor. Thank you.
Okay, take care. Yep, okay. Nessie Shawana Gardner, Manelia Joseph, Melissa Hawkins, and Toshiba Gardner.
Gardner, the first Gardner bonded, Your Honor.
Manelia Joseph,
Yes.
Decline, PD.
you have a warrant, ma'am, for 1,000 on a misdemeanor theft. Thank you. How about Melissa Hawkins? Ms. Hawkins, petty theft, count 1, resisting arrest, count 2. And, ma'am, allegedly stole a 16-ounce Mike's Hard Cranberry Lemonade alcoholic beverage from a Sunoco on Federal Highway in Pompano.
Anything?
Okay, gonna find probable cause. How?
I'll check. It looks like she's out of Gainesville.
Go ahead. Do you have anything? you
Yeah, I
wanna
do,
say?
Judge. Is it possible to consider resolving it for her, first of all? Secondly, she's been here a few months, no family, unemployed, no money, no land or property. She's hoping her mom would bond her out.
Okay.
But for one soda, I mean, maybe we could,
Well, I mean,
not to dismiss it or.
No, I know. I mean, I read what she said allegedly when the police got there. She said, I'm not gonna say the word GD, 4 police cars for this, SH, I only took this. Well, I guess, maybe she believes that if she only steals a little, it's not a big deal, as long as it's not a whole lot.
Yep.
But,
Remember me in your prayers.
people at the shop, well, in the store probably don't think it's that small a deal. Go ahead.
I'll check to see if there's anything out of Gainesville. There's nothing out of Broward. Looks like she's down here out of Gainesville.
Ma'am, how long are you down here for?
I've been down here about 4 months.
And when are you heading back to Gainesville?
Honestly, I'm not sure.
No, lie to her.
Does she say that,
Huh. She's had see, she had a bond revoked in Tennessee in 2012 from failure to appear in 2011. Looks like that was stemming from an open container and underage DWI from 2011. She had 2013 in Gainesville, obtaining controlled substance by fraud. That was, I don't know what this means exactly, dismissed on, oh, she went through pretrial diversion on that.
okay. Ma'am, would you like to resolve your case today?
Yes, sir, I would.
Ma'am, how do you plead to petty theft and resisting arrest?
Guilty, sir.
Do you understand we're not going to have a trial, we're not going to appoint an attorney? Case will be over with today.
These cases that we researched from the
Yes, sir.
Okay, ma'am, I'll accept your no contest plea. You're not allowed to return to the Sunoco in Pompano, all right?
Yeah, when she resets the case.
Yes, sir.
Okay, ma'am, I'm going to withhold adjudication. Thank you.
Thank you, Judge.
That's a domestic in the afternoon, yeah.
Thank you.
What about Toshiba Gardner?
She's present at the main, Your Honor.
Ms. Gardner, you have a traffic warrant on count 1 and 2. Those are 250 and 500. Count 3, resisting arrest. Count 4, driving on a suspended license, 750. Thank you.
Thank you, Judge. Sorry.
Jennifer Weir, Christine Fisher.
Fisher? No. No, they're not here.
Ms. Weir, possession of cocaine, tampering with evidence. Court finds probable cause. Ma'am, your bond is 1,000 on 1, 1,000 on 2. The court previously revoked your bond on 14-2352, CF10 on another case you're out on. You'll be held without bond. Thank you, ma'am. How about Christine Fisher?
Patrice,
Christine Fisher?
is that yours?
Yes, ma'am. Dealing in stolen property, 2 counts, criminal use of personal ID.
Oh,
Court finds probable cause.
Gotcha.
State, do you have any priors on Miss?
Who's this?
This is Miss Fisher.
What's her BCCM?
It's from,
No, what's? Thank you.
she had a 2010 trafficking in oxycodone. Okay. Ma'am, are you currently employed? Fisher, are you employed?
Push the button, ma'am, on the,
Turn on that
there
mic
you
for
go.
me.
Thank you.
I am employed.
What type of work do you do?
I'm a server Windows.
You're what? I can't hear
Just
you.
push it down and let it.
Oh, leave it. Okay. I'm a server at a Mexican restaurant.
Do you have any money in the bank, ma'am?
A couple $100.
All right, ma'am. I'm going to let you bond out today. Count 1, 3,500, 2, 3,500. Count 3, 1,000 based on your criminal record. Thank you, ma'am.
What's the total on the bond then?
Total is going to be $8,000. Thank you. How about?
Thank you.
What?
Push this again.
Whoa. Come on back real quick. Who are we talking about? I have 3 on
Christine
the docket.
Fisher.
I don't know what you're. I've got three charges right here.
Christy was coming down. Yeah. Here, can you just put that over there? All right, I'll take that phone call.
Okay. I have count 1, dealing in stolen property, along with count 2, dealing in stolen property. Count 3, criminal use of personal info. Do you have anything else other than that, State? Those are only 2 charges you have? 3 charges?
Here's the MOs for some MMs and stuff. Well, Sheila just told me. I would go with whatever Sheila says. I think, MOs combined with some of the MOs,
Okay.
MMs we've had.
Well, am I supposed to
You gotta
set
pass them
bonds on
along.
those other accounts also? I'm going to leave the bonds on those counts, all right? Thank you, ma'am.
Have there already been PC determinations?
So what's the total then now? Because it said something totally different on my paperwork.
I understand, ma'am. So, what is the total bond amount, Sheila? I didn't disturb it. 11,000? Thank you, ma'am.
Sir, there's no way to reduce that? I really want to try and keep my job.
Yeah, you know what I'll do, ma'am? I will, count 1, I'm gonna reduce the bond to 1,500. Count 2, I'm gonna reduce it to 1,000, all right? All the other bonds remain. Okay, ma'am? Thank you.
Thank you, Judge.
All right, thank you.
Yes, ma'am. Okay, what about
President
Sam Mosley,
of the Maine, Your Honor.
Alex Edwards, Fabian Booth, and Alan Archie?
Your Honor, Mr. Mosley's president of the Maine. He's here on a KPS. Wondering if it's possible to get ROR'd. If not, can he resolve it?
Sure. You want to plead no contest, Mr. Mosley?
Yes,
You understand we're not going to have a trial. We're not going to put an attorney. The case will be over with today.
Yes, sir.
Okay, sir.
I'll just take it.
How do you plead to trespassing?
No contest.
No contest.
I'll accept that. I'll withhold adjudication. Thank you. Alex Edwards?
Judge, can you make an entry that he gets 6 months to pay that?
Yes, that's already standard operating procedure. Okay. What
Thank
about
you,
Alex
Judge.
Edwards?
Mr. Edwards, president of the Maine.
Sir.
He believes he's bonded out. Any way of checking?
Alex Edwards, is he bonded? So your bond's 100, 250, and 100. So if you bond it out, that's good. Thanks. How about Fabian Booth?
Good luck, Mr. Edwards. President Booth? Booth. Page 9, Booth. Page 9, Booth. Bonded, Your Honor.
Got it.
Archie?
Alan Archie.
President of Maine, Your Honor.
Mr. Archie, you're here for license suspended, count 1. Count 2 is a writ, a purge amount of $876. Count 1, ID card, no driver's license, that bond's 100. Thank you, sir.
Judge, if it's a deed, it says first offense here on the docket. If that's the case, can we go ahead and ROR him so he can go ahead and pay this $876 purge amount?
No, it may say first offense, but I have a whole multiple page driving record where he has no driver's license, where he's been caught driving 1, 2, 3, 4, 5 times operating with no driver's license.
Right. I was just going off the docket. Thank you, Judge.
Got it. No problem. All right, Kamar Garrick, Michael Wick, Roland Chasson, and Nicholas Siddons. Mr. Garrick, resisting arrest without violence. Court finds probable cause. Mr. Garrick, do you still live on Southwest 26th Terrace?
Someone today. Scary.
Answer, sir.
Do you live on that street, sir?
I wasn't listening either. Do you still live at Southwest 26th Terrace? Yes, Your Honor.
I'm going to release you on your own recognizance. Thank you. How
Thank
about
you,
Michael
Judge.
Wick? Michael Wick.
Doesn't mean the case is
Bonded?
over. Doesn't mean the case
What
is
about
over.
Roland Chason?
You're done.
Roland Chase and Conti.
Garrett.
Is Jason's bond listed?
Who are we looking for?
Jason, you're here for disorderly conduct and resisting arrest. Without probable cause.
I'm sorry, sir?
I find probable cause for these charges.
Don't say anything, sir.
I'm sorry, sir. I'm kind of dizzy because I didn't have medication. But you find probable
You've been bonded,
cause.
sir.
Yes. Please get a question.
I'm really confused, sir. I told my doctor.
Go ahead, ask the question.
Okay. I had a bond. I was arrested on Monday.
Right.
And I was low on pills. I know that I get excited.
Wait, hold on.
Yes, sir?
Your bond has been posted. You'll be out of jail shortly. You'll have to.
I thought it was.
You'll have to
Yeah.
come back to court in about a month or so, and at that time you can tell the next judge about your case. All right?
Oh, I misunderstood. Thank you very much,
Okay.
sir. Very nice of you.
Sir.
So I can get out today, you
Yes,
say?
sir. Yes, sir.
Thank you very much.
Au revoir. Bonne nuit.
Very good of you, sir.
Well, we try to make the
Okay.
Canadians happy.
This
sir.
is slowing things down. If you
All right.
get out.
Okay, so Mr. Wick on page 10 did bond.
Probably, I don't remember, but
No, I'm telling the court now. And now, on page 12, we have Ricardo Britt. It's carryover from the morning. There was an issue. We hadn't seen the PC. There was we hadn't seen the arrest warrant. We're stipulating the arrest warrant.
okay. Just let me
is
take care
satisfactory.
of this one case. Where's Nicholas Siddons?
He's right here, Your Honor.
Sir, a warrant on a felony, no bond. A warrant on a misdemeanor, $250, and you have a writ, a purge amount of $777. Thank you.
Got it. Thank you. Good luck.
Mr. Britt. From
Britt.
this morning.
Right. So we're going to stipulate that the arrest warrant is sufficient for probable cause. However, he's being it's showing us a first-degree felony, and he's being held no bond. I think it should be a third-degree felony for the tampering with a witness. We'd ask the court to set appropriate bonds based on the allegations in the case.
And that's what I was telling you this morning, Judge.
Right.
that
So,
Patrice. This turn.
okay. Give me a quick moment. So I'm gonna find probable cause to battery, count 1, tampering with evidence, count 2. Now it says Let me ask, Steve, does he have any priors?
Yes, Your Honor, just one moment. I don't know if you want to inquire from him any information.
Oh, this is really, anything you want to add on this defendant, sir?
Judge, I've talked to Mr. Britt. He's not going to be able to post any bond that you set today. He's asking the court to set to give him a SAP order, and hopefully he can get some help and deal with all of this later on in division.
And Your Honor, I can confirm that.
Need a guardian for the child in this case. So I'm going to order today while we're figuring this out. You're not allowed to have any contact directly or indirectly with the alleged victim in this case. And let me just look here.
I don't think, and to answer your question, Judge, before you ask it, I don't think it mentions.
I don't think it
mentions.
mentions a child and.
Okay, so
unless I missed it.
Who's the alleged victim?
The victim, not
It mentions her name.
I don't think it does either, Your Honor. But I also don't think it mentions the child. Oh, there it is. I see it now. Forget it.
Yeah.
Is she coming in here and say good things? Is she gonna come in here and say good things?
She was scared because I was messing with another girl.
For her to come in here and speak? Oh.
She tells you. I ain't know you out here. Yeah, that's y'all in there.
There's really.
Can you believe this?
I know, Judge.
This is just unbelievable.
Yeah, I'm just gonna ask if the court could. I would just ask the court to issue an order of no victim contact. If there's an issue at a later date, we'll have to deal with it then. I'll make a note that Your Honor's not able to name the list of victims this time, and hopefully we can take care of it as quickly as possible.
Okay, Mr. Anything you want to add? Anything else, Mr.? Okay.
Just
we
need that SAP order, Your Honor,
I got
and a reasonable bond under the circumstances. I understand the court's in a kind of a position of having to set a serious bond, but right now he's not going to post anything anyway. So.
Yeah. It is referenced in the affidavit in 2013. He had a battery and culpable negligence against Lizbeth Lorero. I don't know if that's the same victim as in this case.
Okay.
Also in 2013, he had a violation of pretrial release conditions. That was the no contact order from the battery case.
Okay.
And, one moment, Your Honor. There is Ms. Lorero does have a permanent injunction in place. Matter of fact, Your Honor, I can't swear to it, but I can tell you that Ms. Lorero got an injunction January 27th, 3 days after this allegedly occurred. So I think it would be safe to say that Ms. Lorero is probably the alleged victim in this case.
Sir, I just want to note, January 24th of this year, you allegedly became highly intoxicated and went after, I'm not sure, your girlfriend, the mother of your child, struck her in the head, struck the woman in the head, torso with open hands, fist. She had a knot on the side of her head, bruises, marks. Said you went into a rage, began to kick and punch holes in the walls throughout the residence, removed dresser drawers, threw the dresser drawers at her, causing bruises and marks. Continued on your rampage, kicking the bedroom door off the hinges, then throwing the door at the woman, hitting her with it. After several hours of abuse, you fell asleep. She was able to leave the residence, and then struck her again in the face, and then broke her new cell phone. Allegedly, you told her if she called the police, you reported the incident, you would harm her. It says that you flattened the tire in her vehicle, slashed the tire in her vehicle, and when she got home from that, you allegedly abused her again. It should be noted, all of this was done in front of the 3-year-old child.
Yeah,
And even the 3-year-old child gave a taped statement. The detective was reviewing the photographs of the residents. The 3-year-old child said, "My daddy did that. Take him away." So that says a lot right there. Very concerned about the safety of the mother of your child, concerned about the safety of your child, what appears to be a violent rage you went into. The court's concerned there's a big safety issue. For the mother of your child, I wish I knew her name. The police detective did not put her name in the police report or the child's name. So I'm going to order you have no contact with the mother of your child, no contact with the woman who's mentioned here or who's listed here. Don't have any contact with her directly, indirectly, no contact with the child. I'm going to set your bond on count 1, and I note you've been convicted of battery, culpable negligence, and violating a no-contact order in the past. Count 1, the battery, I'm going to set the bond at $50,000. Count 2, tampering with evidence, that bond will be $15,000. Your total bond, $65,000. Pretrial release level 1, GPS. I'll waive the cost. Thank you, sir.
Yeah. Okay. You're welcome.
How about that SAP order, Judge?
I'll
Got it.
do that. Okay, Daryl Thomas, William Bynes, Derek Manboard, and Jeffrey Daly.
All right. Mm-hmm. Bye. We just had Lamar McCulloch from Reset in the Morning.
Christian Thomas, President of Maine, Your Honor.
For a
All right,
3-year-old.
Daryl Thomas.
Yes.
Dealing in stolen property, false ownership of pawn items. Court finds probable cause. See, do you have any priors on this gentleman?
Yes, Your Honor, one moment.
Thomas, are you working at this time?
Yes, yes, sir.
What type of work
Yes, sir.
do you do?
I do AC. I fix ACs for houses and business.
Do you have any money in the bank?
No, sir.
Fines.
Who's going to bond you out today?
Patrice.
Um,
Cocaine. Do you have anything else on Daryl Thomas?
my boss man say if I can get the bond a little bit lower, he'll help me bond out.
Does he have any priors?
I'm just showing possession of cocaine from 06. You know, he must have had other stuff because he violated probation, was sentenced to 3 years.
That's right.
That's all you have?
You know,
He's done that.
But he didn't call him, he called Daly.
Right.
He's back in order then.
so I'm going to set your bond today on count 1 at $1,000, count 2 at $1,000. Total bond's $2,000. Thank you.
Thank you, Judge.
Thank you, too.
How about William Bynes?
He bonded, Your Honor. Manboard, come on.
1,000, 1,000. How about Bynes bonded? How about Derek Manboard?
President of Maine.
Sir, count 1 is a violation of probation, no bond. 2 through 5 are all traffic warrants. 250, 150, 150, 150. Thank you. Jeffrey Daly.
You're going to see Judge Gold on Monday. Go down the middle, please. Mr. Daly is President of Maine. Moving a little slow today.
Sir, possession of cocaine. The court finds probable cause. Are there any priors on this gentleman?
He went through drug court in 2013 on 2 separate cases of possession of cocaine, dealing in stolen property, 08.
Okay. Sir, are you currently employed, Mr. Daly?
I'm currently on disability and independent contractor.
Do you have any money in the bank?
No, I do not.
Okay. Who's going to bond you out today?
I have no one.
Your Honor, I was talking to Mr. Daly. He's advising that he served in the Navy for about 8 months. He was a seaman first class, so it tells you how long ago it was.
Wow. All right. So, so I'm going to release you on your own recognizance to go to pretrial release. You need to be there tomorrow between 8 and noon. They'll give you a map right
Thank
there. Thank you.
Thank you.
Nope, he's done.
All right, Roderick Bacon. Do you have Bacon in the main jail?
He's still on
Medical reset, Your Honor.
Your Honor, I can tell you, because just so you know, and we'll deal with the case whenever it comes through, I talked to the officers involved. It's on Flacco.
Really?
So I'm guessing that has something to do with why he's on loan.
Yeah. All right. Well, I'll just flip this over to tomorrow. Friday. PM. Here you go. Yeah. Okay. There you go.
Celentano is in North Broward, Judge.
Okay.
Very
All right.
tragic.
Sorry about that. Okay. What about George Celentano?
North Broward, Judge.
I got it.
No problem, sir.
This is kind of a, well, it says robbery and grand theft. It may kind of be a pumped up, resisting a merchant. Depends who the officer who's writing the report. Defendant removed groceries, electronics, a 55-inch TV from Walmart, put them in a shopping cart. When the police, or they started noticing the man, he started running away in the parking lot. And allegedly, he pulled away from her and swung at the person working there. So,
2009, 3 counts of felony withholding information from a medical practitioner. 09, felony petty theft and resisting a merchant. 05, solicitation to deliver cocaine. 99, theft. 96, resisting without violence. 96, DUI. 94, tampering with evidence of the VOP. 91, battery. 85, aggravated assault with deadly weapon, criminal mischief, VOP, 24 months. 88, resisting without violence and disorderly conduct. 83, burg dwelling, grand theft.
okay. Sir, are you currently employed, Mr. Celentano?
No, sir.
And how long have you lived down here in South Florida?
30 years. 30 years.
All right. And when was the last time you were employed?
Last year, 6 months ago.
Well, how do you pay your bills? Where's the money come from?
Well, I'm coming off and on to do jobs, side work.
Okay.
Coffee.
Mr. Celentano, you've been known as George Steed in the past and John Celentano. And I do note that, sir, you have a long history of felony petty theft, grand theft, burglary, aggravated assault, battery. You've got a very long history here. Okay, I'm going to go ahead and I'm going to set your bond today. And set your bond on count 1 at 7,500, count 2 at 1,000. I'm going to let you bond out today. Thank you. Okay.
Judge.
Yes.
Main jail. If the court could please set Lamar McCullough. He was a reset from this morning. He didn't make the docket, but we need him on tomorrow afternoon's docket, please.
Okay. It should have been. I'm going to put him on PM tomorrow.
Thank you, Judge. And we have 3 second looks over here.
No, yeah. I'm going to move him over to Friday PM. Go ahead, sir. What was
Thank
that?
You, Judge. We got 3 second looks. You can go.
Yeah. Who was that?
I don't know. Come on, guys, line up. What's your name?
What's
Anthony Del Persio.
Del Persio.
When you say he has nowhere to go, what do you mean he has nowhere to go?
Not talking about me.
Okay, take control off, put the bond back on him. All right. Okay, now, who do you have right in front of you there, Mr.
Tell the judge who you are.
My name is Anthony Del Persio, sir.
I didn't print a second look docket, Your Honor. I'm not sure why he's here.
I was
I don't
told by
see him on
my
a second
boss-
look either. Del Curcio,
My boss told me.
right?
Okay. Del Curcio?
Del Persio was a P, sir. My boss told me that pre-trial had called him and
No,
contacted
no,
him.
no.
And
Mr. Del Persio, we're not even there yet. I don't see you on the
Oh.
docket. Is he on the docket?
What's his first name?
What's your first name, sir?
Anthony.
I thought he was on yesterday. Maybe I'm wrong.
I was on yesterday.
He was here yesterday, Your Honor. Do you have that second look?
Yeah. Yeah, no, he came through. You checked his priors. You said sending it to division.
Okay. Sorry we got you here today, sir. This is by mistake. Thank you. Go ahead.
I hope it was entertaining, at least. There you go.
Thank you.
Shane.
Sorry.
Shane what? Shane South, Your Honor. I think he's here on a 30-day.
Yes, Your Honor, we've not filed an information yet. He's entitled to release.
I don't have
Mr. South, you're going to be released to ROR on 15116 CF10. Thank you, sir.
Just remember that the case is not over. You have to stay in touch with the clerk. How'd you go? You're gone. You're going. For real. Tonight. What's your name, sir?
Jamal Michaels.
Jamal Michaels?
Jamal Matthew.
Jamal
Matthew. Matthew.
We've not yet filed. He's entitled to release. Drew.
Okay, hold on one
Right.
moment.
Okay, again.
Wait, what?
Yeah, took Daly off pretrial, gave him back a bond back. He had nowhere to go. He didn't qualify for pretrial. There you go. So took care of those two.
We are clear at the main, Your Honor. I'll see you tomorrow.
You're welcome. Take care. Okay, so now, seems like I was in the middle of doing something. All right. Let me do the two. I'm on the misdemeanors right now on the computer. Where's David Burns? David Burns. David Burns.
How are you, Ron?
Hi, sir. Sir, you're here on a DUI. How come you haven't bonded out yet, sir?
The situation is that my bank account, I have money in my bank account, PNC Bank, but I have no way to get it out. My phone numbers are all in my personal property. They won't let me. They won't let me get it out.
How long have you lived down here in South Florida?
Year,
Do you have
about a
family
year.
down here?
Up in Fort Pierce,
How often do you
sir.
speak with them?
Not that often.
No? What do you do for work?
I have 3 different jobs. I'm a music teacher. I teach students privately guitar, bass, and drums. I also work at pizza place Annie's Pizza, which I'm about to. If I don't get back to work, I'm not going to be able to get there. And Universal Resorts and Tours. I sell vacations. I mean, I haven't drank in a long
Hold
time.
on.
You know.
Wait. Just hold it right there. Let me look at something. I wasn't your judge when you came through here. Does this man have a criminal record?
I'd have to look, Judge. Unless, Patrice, you don't have notes done, so do you?
I don't.
So, I guess you can understand how we don't always take the word of the person in jail. You know what I mean? No offense to you, but
Don't say anything,
trust
sir.
but verify.
Just hold on.
Just like Reagan told
No
Gorbachev,
problem.
you know? That's it, Rose. Point 104.107. He said he has a prior DWI, however, was not able to locate it. Do you have anything, State?
I'm checking right now, Judge.
Do you still live on 20th Court in Margate?
Yes, sir.
It's
Go ahead.
It's right over there. Top, right there. Okay. The database is looking into it right now. Right there, there you go. And he got transferred to Judge Look right now. Yeah.
Phone number down.
I'm not seeing anything.
I'm going to release you on your own recognizance, Mr. Burns. Tomorrow morning between 8 and noon, you need to be in downtown Fort Lauderdale. You have to go to pretrial release, all right?
Okay.
Is that clear?
I'm not sure with that. I'm not clear with what.
They'll give you a map.
They'll give you a map right there. Just ask the gentleman for a map. He's going to give you a map. It's right across from the downtown courthouse. You know where that is?
I guess I'll find it.
Well, it's on the map.
Map will show you.
The map. Everybody knows where the courthouse is. Just ask some people. You have to go right across the street from the courthouse tomorrow morning between 8 and noon, all right?
So you're being released. You're being released with no bond, sir.
Sir, sir, hold on. You don't look a gift horse in the mouth. I'm letting you out of jail. You're gonna have
Thank
to.
you.
You're gonna be breath tested every week to make sure you're not drinking anymore, because you're not allowed to drink. Is that clear?
That's clear.
Okay. The other thing is, what you should do tomorrow is go out to the Department of Motor Vehicles, take your DUI traffic ticket with you, go out there and get a temporary driving permit. So you've only got 10 days from your arrest. You've already burned up 5. You only have 5 more to do it. I'd do it tomorrow if I were you. All right?
I'll be able to do that. So my license is no more right now?
Correct. You have to go out to the DMV and have them reissue a license, all right?
Okay.
You got it?
So I'm released now.
Not this
Thank
minute,
you.
but you'll be out of jail this evening, all right?
Thank you.
Yes, sir. Wow.
Thank you, Judge.
Is that it?
That's it.
Okay, we got a couple more here. Where's Stephanie Rosier? Roser? Stephanie? Stephanie Roser, is she over there? Did she bond out?
I don't know. Well, she's not. She might be there, but she's not there.
She's not there, so we're gonna, you know.
Wait a minute, Paul Ryan, Rosser? Deputy, somebody.
Deputy, is anybody over there, Paul Ryan? Deputy, can you come
If
forward,
they hear
please?
us, because clearly he does
Here you
hear
go.
us.
Deputy?
There you go. Good luck.
Hey there.
Yes, sir.
Do you have
How are
Miss
you?
Stephanie Rosser there?
Stephanie Rosser?
Yeah.
I would have to look for her, Judge.
I'm gonna reset her for tomorrow afternoon, all right? Thank you.
Okay. I do have one person here, though.
Who's that?
What is Dan Cooper.
Come on up, Mr. Cooper.
It's a 30-day. It's filed on Odyssey.
Go ahead, man.
Mr. Cooper, just give me
Yes,
a
sir.
moment, sir. Mr. Cooper, I'm looking on the clerk's computer on February 5th, 2015. It says the state of Florida filed a formal charge on you, so known as an information. State of Florida versus Dan Cooper, charged with count 1, possession of a firearm by a convicted felon. Count 2 is trespassing on a structure. No, I'm sorry. Yeah, it's just basic trespassing, misdemeanor. Let me look here. That formal charge was signed and sworn to by Mark Horn, State Attorney's Office, February 5th, 2015. So, any comments by the defense?
When you say that, when it was filed, sir? The charge was filed?
February 5th.
That's the day?
Yes, sir.
Still have to bond out, sir.
Sir, on 15109 CF10, the court will deny the motion to release you ROR. You're still welcome to bond out, sir. Thank you. Okay. How about Gregory Buchholz? Buchholz?
Has been filed with the ROR.
Right here, Your Honor. How you doing, sir?
Good, Mr. Buchholz. Sir, I'm going to release you on your own recognizance today, all right?
Yes, sir.
But we're going to do it anyway. Go ahead. Why?
It wasn't showing up in my system. I don't doubt pre-trial.
Well, he got a break today. All right? Device fund is set at ROR. I'm going to release you on your own recognizance, Mr. Buchholz. I know, I did think that he was trying to digest the whole thing. He's like, golly, am I lucky? They don't even know about my criminal record. You know what's also very telling is when you say, hey, the person has 2 prior DUIs, and they stand there and they have poker face. If I didn't have 3 DUIs, I'd go, that's not me. Okay. Sam, where's Sam Vidal?
The officer admits he couldn't find it, but who tells an officer? Yeah, that
Sentinel copy, sir.
trying to impress.
Sam Vidal, what's this?
No, I don't know what this is.
Sam Vidal, hold it.
This is a second one.
Sam, how come you haven't bonded out of the jail yet?
I have no means of bonding out, Your Honor.
Well, how long have you lived down here in South Florida?
I've lived here for 8 years. I don't have any family here. Very few friends, and I just don't have any means. I don't have the money. I am employed.
What type of work do you do, Mr. Vidal?
I'm a computer technician.
Really?
Yes, I just started the job about 4 months ago.
Okay.
and I do have a residence. It's in Boca Raton.
Right, and you're here
Broker,
for,
you can't afford a $1,000 bond?
you're here for possessing cocaine, resisting arrest without violence, driving on a suspended license. 2010, a burglary in West Palm, burglary tools, cocaine, and in 2006, a cocaine. So this will be your third cocaine, along with the prior burglary. So,
I'm just, I guess I'm.
give me a moment. Just give me a
Hey,
moment.
no, hold on, sir.
Yes, Your Honor.
Just make sure that. See what we're doing. I don't have an address for you. Do you have an address in Delray?
No, I have an address in Boca Raton. It's 11033 Seashore Lane, and that's Boca Raton 33428. And my landlord's number, I can't remember it. I gave it to the pretrial and on the machine at pretrial. They called me up for pretrial a few days ago.
Okay, sir, it's been verified. I'm going to release you on your own recognizance, all right?
Yes, Your Honor.
Thank you, sir.
Thank you.
Yes. What about Christopher Seymour?
Hello, Your Honor.
Now, Your Honor, we have not filed charges. He's entitled to release. We would just ask, since this is a domestic violence case, if you could advise him that there's still a no contact order in place.
Mr. Seymour, on 15118 CF10,
Yes,
I'm going to release you on your own recognizance today. I want to remind you, you're still not allowed to have any contact with the alleged victim, all right, sir?
Yes, sir.
Sure.
There you go, sir. Thank you.
I was talking to Drew.
Thank you. You're done. You'll be out of here shortly.
Yes, sir.
Okay, I think
Necessarily
that's a wrap. Am I
predictable or
correct?
something like this, but not
Let's
names
wrap,
illegal.
everyone.
But like I said, I understand it.
Today,
I understand how parents would be like, I don't hold
is
it against
Thursday, am I correct? Today's
Is it?
Thursday, right?
Yes.
And everybody
sure.
knows what comes right after Thursday? Most of the time, it's Friday.
Drinking?
And that means that if it's Friday, it's Bow Tie Friday in this courtroom. It's the most festive time of the week. It's where everybody kind of celebrates the end of the week. And where's the bow tie? Unfortunately, I continue to be the only one who celebrates today with the bow tie. But I encourage anyone to turn the corner and just wear your own bow tie. Carl will wear one. But Friday, we're going to be here bright and early at 8:30 in the morning. Until then, we're out from room 235. Thank you. See you tomorrow.